Hello business friends. First of all, let me wish you a very happy Lori, Makar Sankranti, Pongal, Bihu. Until now, I have made a lot of videos on protecting the business capital by way of using law to recover your outstandings and aged outstandings. In continuation to that, and in same vein, I would like to take up a very important clause which is liberally used by the employer of a contract. The contracts could be government, it could be private. They have a penal provision, and this penal provision is enforced the moment there is any kind of delay in executing the project. It becomes very pertinent in these times of uncertainty when the state government and central government is enforcing a lot of curbs, restrictions to cut the transmission chain of the virus. This could be one of the reasons why any project in hand could get delayed. But the employer of the contract would take this as an opportunity to use it as a discount and enforce the penal provisions. Kindly watch this video until the end and understand the penal provision, the law behind, and the way to manage it. How you can prevent the employer of the contract to enforce this penal provision. This video would help you in that. Let me first take you to typical penal provision of a contract, which is standard language. There is something called penalty and there is something called pre-estimate of liquidated damages, in short form LD. Any business owner would be aware of this LD clause and would have suffered because of this. Because this normally in the final payment or the final bill when it is submitted of a project is used. Coming to the fact as to what is the difference between penalty and LD. I will use the Hindi term which is borrowed from Urdu called Jurmana and Harjana. People from North India and the Hindi belt would understand this very, very well. Penalty is the Jurmana, while LD is the Harjana. I will further explain by taking an example. If you're driving on the road, if you commit a traffic violation, you will be penalized. A challan would be issued, and that is called penalty. While driving any vehicle, if you meet with an accident, and that accident causes some kind of damage to the other vehicle, then you need to compensate the affected party. This compensation is basically liquidated damages. Now, let us try to understand how penalty and LD are understood by various courts of this country, be it the High Court or the Supreme Court of India. As far as penalty is concerned or the LD is concerned, they are underpinned by the Indian Contract Act 1871 under the section 73 and 74. That means these provisions of penalty and LD are lawful. Then when do they become unlawful is what we are going to discuss in this video. Coming back to penalty, the Jurmana, in the view of the court, it is in terrorem. In terrorem is a Latin word, and in English it means a deterrent. It is basically a deterrent not to commit any traffic violation. Similarly, in terms of a business contract, meet the timelines earmarked in the contract. In case you overshoot the timelines, then you may be fined or you may have to pay a penalty. So that is the provision of a penal clause. The courts feel that these penal clauses are not enforceable, especially if you do not find the reason, the correct reason for delay, they are not enforceable. And in case there is a dispute over a penal clause, you can go to court and you can dispute it. Now coming down to the liquidated damages, which are phrased as pre-estimate of liquidated damages. In many business contracts, you would find this clause called time is essence of the contract, which means the employer of the contract who's getting the contract executed, he would suffer some kind of a loss in case this project is not completed on time. Keeping that in mind, while executing the agreement or executing the contract, he would put some kind of value that in case the project gets delayed, then this much of loss I can suffer, which is called the pre-estimate of liquidated damages. What does that mean? The courts of this country are of the view that this pre-estimate of liquidated damages is the upper cap of the damage which the employer of the contract can seek from the contractor in case there is any kind of violation of the timelines. But in absence of any kind of loss not suffered by the employer of the contract, this LD is not enforceable. I again repeat, if the employer of the contract does not suffer a direct loss because of delay in execution of the contract, then he cannot deduct LD. The LD deduction would be unlawful. Further, how can you prevent the employer of the contract from enforcing liberally this LD clause and the penal provision? Various courts of this country have given judgments, rather pronounced judgments, that these penal provisions and LD is enforceable only if the contractor is solely responsible for the delay. The courts are of the view, and this is a fact, that in any contract there are reciprocal obligations which the employer of the contract has to fulfill or perform. And there could be a delay in that also. For example, in a civil project, there is a drawing, and this drawing has to be given by the employer of the contract. If there is a delay in giving the drawing to the contractor, there is going to be an overall delay in the execution of the project or delay in construction of the structure, which means the delays could cascade because the employer of the contract did not perform its obligation on time. These courts term this as concurrent delays, which means in case of a delay which is solely attributable to the contractor, only then if there is a loss suffered by the employer of the contract, the LD clause can be enforced. Let it be very clear, business friends, that do not accept any LD in absence of any direct loss to the employer of the contract. Now, what is the tip to remember? During the progress of the contract, business owners, please keep recording the delays of the employer of the contract. Keep writing them mails, that yes, you have not performed this obligation as per the contract, which is why we are not able to perform the dependent obligations. At the end of the project, if the employer of the contract issues a show cause notice as to why LD should not be levied, you can make a legally tenable letter and inform them that you are not solely responsible for the delays. So, if any LD is levied, it is unlawful. Business friends and business owners, in these times of the pandemic, protect your capital from eroding because cash is the king. Please remember that. Keep making profits. Thank you for watching this video. Goodbye.